Hi, Bill Chatt, aka Bowtie Bill, and Bob Prince with the Cervantes Chatt and Prince Legal Minute for Friday, December 13th. We are here to talk about one of the amendments to Illinois state law that is coming up in 2025. It's going to amend the Condo Act, 18.12 it'll be, which has to do with handicap parking within associations. Previously to this amendment to the Condo Act, this issue did exist. It had been handled through a federal case that was brought by, I want to say it was HUD. It was the Jaffrey case. Yeah. So I've dealt with it a number of times this year, and previous to this amendment to the Condo Act, I would cite the case of this Jaffrey case and say, hey, look, here's the issue. Someone comes to the association and they are in need of a handicap spot. Maybe they have one of those accessible vans and they need the ramp to come out, or whatever the reason. They've got a genuine reason for it. They come to the association, and a couple things. Maybe, and this happens once in a while, you have someone who has the handicap spot who really doesn't need it, at least at this time, or you don't have any handicap spots. Two different scenarios. But in the first instance, where someone does have it and doesn't need it, this Jaffrey case says that the person who has the handicap space that doesn't need it needs to, at least temporarily, switch with the person who needs it. And so that's how we were dealing with it, was this Jaffrey case, was case law. Now, the Illinois legislature has adopted this amendment to the Condominium Property Act. And so what are the talking points on this amendment?
So the first thing is if the association has common element spaces that are accessible parking spaces, we cannot transfer those we cannot sell those. We can't make them non-handicap parking spaces. They're going to have to remain that. That's actually already Illinois Accessibility Code. We're already not supposed to do that, but now it's codified in the Condo Act that we can't do that. Another thing is that in the event the association doesn't have any spaces, the association has to work as an intermediary between potentially two owners to try to procure a space for an owner who is disabled who needs a parking space. And that's like the Jaffrey case.
It just popped in my head. More of a downtown thing. You got someone that's got two spaces.
If someone has two spaces, you might have to broker that deal. You might have to involve yourself in the context and the negotiation of it. Interestingly, the statute doesn't say we have to obtain the parking space for someone. We just have to participate in the process, which I assume means in good faith that we're actually trying to make efforts versus just trying to look like we are. So if the association has parking that somebody needs, we'll have to provide that person with a better space so that they have access to it. It could mean that if there is some deeded or limited common element space that this owner already has, but it's further away, they may have to transfer theirs to the association, at least temporarily, so that way it's a trade of their old space for their new one. There are some also provisions in there about new developments or conversions with parking areas that they'll have to have accessible spaces, and they cannot be traded, sold, or otherwise. And if a developer does that, they could be subject to suit. So there is some private rights of action that are going to come out of this that people will be able to sue to have enforcement for it, which could include punitive damages. It doesn't say attorney's fees, but I assume that's what they're talking about when talking about punitive damages, as well as compensatory damages and the such.
And like the ombudsman that they put through a few years ago and the solar policy, which they flip-flopped on, this has to be a written policy, right?
It does. Associations have to adopt a policy within 90 days of January 1. So that's basically the last day of March, April 1st at the latest, depending on how you count. So associations will have to have a policy in place. And then anytime an owner requests that policy, we'll have to provide it to them. So I assume when you're adopting that policy, we're distributing it to the entire membership anyways, because it's a policy we're adopting. Right. But a future owner who's going to request that policy thereafter, we have to provide it to them. Right. And then for decisions on a request, an association has to respond within 45 days. That probably means you have to have a board meeting, if not two, within that 45-day window. So associations that do quarterly meetings, it may not always be quarterly anymore. I personally have some concerns about whether 45 days might be too long. Under HUD guidelines, I mean, this would be technically a request for a reasonable accommodation. And 45 days could be viewed by HUD or the Illinois Department of Human Rights as being too long for somebody to be able to receive an accommodation response. So it could be, sticking to that 45-day window could cause trouble. So even if we adopt a policy that has 45 days in it, an association may be, should be encouraged to potentially act sooner than the 45th day.
There's no doubt we are going to, as practitioners, get a lot of what if, but what about this, but what about, there's no doubt. I mean, having been in some of the buildings of the associations in Chicago we represent, I look and oh, there's a spot, but it's the fire area and it's now we've got a conflict between fire code and things like that. Obviously we can't block this. I know we're getting a lot of what if, by all means, go ahead and contact us, we're going to take it one at a time. Let me throw this one at you. The discussion of the board, this 45-day period, closed session or open session?
I would think the decision, no matter what's going to be an open session. We know that. The discussion of it would probably be at a closed session.
Because there's some legal aspect to it, right?
I would say you're going to be talking to your legal counsel related, at least I hope you are. Yeah. It's probably a really good idea to do.
These particularly.
You get a paper trail that protects the association in case something goes wrong. So I think that would be part of a legal discussion amongst the board members. But the decision obviously will be made at an open meeting, just like all the other ones are made.
Okay, yeah, that was my take of it, and we're a lot to TBD on this one. But yeah, you're going to want to reach out to your practitioner, whether it's us or someone else, and get going on a written policy, because that's going to it's going to be a little bit different. It's not like the solar policy or anything like that. It's going to depend on what your common element layout is. Can anyone possibly get kicked out of a building so that someone can have a spot? There's a lot of what if in this one. But again, I guess maybe the saving grace is it's reasonable efforts, which, just like good faith, that's been litigated to death. So we'll see what happens. And that's about it for us for this topic.
Have a great day.
Take care.